Hello, hi guys, how are you? Hope you people are fantastic. Even I am doing well. Now, basically, in the previous class, we have completed a introduction of Companies Act. All those topics which we have learnt at our CMA inter level. That was the first chapter in Companies Act. Now, in this class, we will be entering into second chapter of our Companies Act. Okay, this chapter you have not learnt at our CMA inter level. Okay, this is present only at final level. And if you see your institute's study material, there you will find the name of the chapter, the name of the second chapter as loans and investments. This was the name of the second chapter in your institute's study material. But in this chapter, there is only one section that is related to loans. Okay, section number 186 and 187. Okay, these two sections which are related to loans. And apart from these two sections, section number 73 to 76A, okay, we have around some 5 sections. Now these two sections are related to loans and investments, and the remaining all sections, remaining 5 sections are related to deposits. Okay, and also these two sections are there na, related to loans. These two sections you will be able to understand only after you understood the concept of directors. Okay, only after you understood the concepts related to meetings of board, okay, appointment of directors. Only after understanding all those concepts we can discuss these sections. Okay, this is somewhat advanced section, you can say. So, and also in order to understand this section number 186, you should also understand section number 185. There is a link between those two sections. So what I have did is, I am not covering this section now. Okay, I will be covering this section while dealing directors chapter. Okay, here I will be covering, okay, in this chapter I will be covering only related to deposits. Okay, thereby in my book you can find the name of second chapter as acceptance of deposits by companies. Okay, even the institute should have given this name to that chapter, but I don't know why institute has gave the name of the chapter as loans and investments. And even this section should not be placed in that chapter. Okay, if you read this section in this chapter, you will not be able to understand that section. Okay, thereby I am not discussing these two sections, section number 186 and 187 here. Okay, we will be discussing it while covering a directors chapter. Okay, now here we will be exclusively dealing with deposits. Okay, now if you see the name of chapter, acceptance of deposits by companies. Now first of all, what is meant by deposits? Generally, deposits are a type of loan, you can say. A type of loan. Let's say there is SBI Bank. Okay, now SBI Bank will accept saving deposits. Okay, it will also accept fixed deposits. Okay, now in the same way, companies, since SBI is a banking company, its main business itself is to accept deposits, whereas companies, now generally companies, okay, various manufacturing companies and trading companies, various companies requires money in order to conduct their business. Okay, there are various sources from which money can be raised by these companies. Okay, firstly they can take a loan from banks. That is one of the source. Just a second, I'll just close this and open again. Yeah, see, companies can raise amount from various sources. First one, loan from banks. Okay, or it can raise money from public through IPO. Okay, initial public offering. By issuing the shares of the company, it can raise money. Okay, it can issue debentures. Okay, it can also raise money by issuing debentures. In the same way, it can also accept deposits from the public. Okay, deposits from public. Now, deposits has become one of the sources of finance for the companies. Okay, they will be raising money from the public in the form of deposits. Now you can get a doubt, what is the difference between deposit and debenture? Okay, generally loan means, you know, loan from the bank, it is a debt, and IPO would be equity. By issuing equity, company will be raising money. And in case of debentures, the entity will issue debentures to the public and it will raise money. Okay, even debentures are also one of debt instruments, you can say, debt instruments. Okay, on these debentures, amount raised through debentures, company will be paying interest. Okay, in the same way, on deposits also company will pay interest. Okay, and even these deposits are also debt to the company. Okay, public will deposit amount with the company and company will pay interest to the public. Now, why company will raise deposits instead of raising debentures? Okay, it can issue debentures now. Why it is raising deposits? Generally, debentures will be raised for long term purposes. Okay, generally the maturity period of these debentures will be between 5 to 10 years. Okay, it will range from 5 to 10 years. These debentures are long term form of finance. Okay, for the companies, whereas these deposits are medium term finance. Okay, generally the tenure of deposits will be 6 months to 3 years. Okay, this will be the tenure of deposits. Okay, within 3 years or 6 months. Okay, based on tenure of the deposit has to be repaid to the public by the company. Okay, thereby the main difference between debenture and deposit is that debentures are long term finance, whereas deposits are medium term finance. And also here debentures are securities. Okay, once company raises money from the public through debenture form, it will issue debentures to the public. Okay, that would be a security. Okay, debenture security will be issued to the public, whereas if company raises money through deposits, okay, it will issue deposit receipt. Okay, now this deposit receipt is not a security. Okay, like equity share, like a debenture, like a preference share, this deposit receipt is not a security. Okay, this is the major difference between debenture and deposit. Okay, both debentures and deposits are debts that the company will raise. Okay, these are two forms of sources through which company will raise money from the public. Okay, Now this is a brief idea of what deposits are. Now here if you see, in case of deposits, public are involved. Okay, in case company after raising deposits, if it fails to repay the deposits, there will be loss incurred to the public. Thereby Companies Act, okay, regulates this deposit transactions. Okay, regulates deposit transactions. Okay, generally it specifies various restrictions on raising deposits. Okay, it will also specify various regulations and provisions that has to be followed by the companies that are raising deposits. Okay, all those we will be discussing in our chapter. Okay, hope this is clear. This is what we will be discussing in our chapter of acceptance of deposits by companies. Now if you see in the Companies Act, okay, in the Bare Act, this entire topic is covered by a separate chapter. Okay, there is a separate chapter by name acceptance of deposits. Okay, in Companies Act 2013. Now in Companies Act 1956 also there is a particular chapter relating to these deposits. Okay, at that time the name of this chapter was public deposits. Okay, see, I am not saying it in the institute material, in the Bare Act. Okay, in the Bare Act we will be having chapters now. Okay, in those chapters the concept relating to deposits, okay, is under the chapter name public deposits. Okay, under 1956 Companies Act. Now in Companies Act 2013, this chapter name of public deposits has been changed to acceptance of deposit by companies. That means here what we can observe, previously deposits can be raised only from public. Okay, and only public companies can raise deposits previously in Companies Act 1956. Okay, but now under Companies Act 2013, this term public deposits has been removed. See, if you see in the name of the chapter, you don't find the term public. Okay, it is just acceptance of deposits by companies. That means both private companies and also public companies can raise deposits. Okay, and also deposits can be raised not only from public, deposits can also be raised from members also. Okay, from shareholders also deposits can be raised. Hope this is clear. This is brief idea of this deposits chapter. Now if you see, there are 5 sections that are covered under this deposits chapter. In these 5 sections, only 2 sections are important. Remaining 3 sections, very small sections and very irrelevant sections, you can say. Okay, if you see section number 73, which deals with prohibition on acceptance of deposits from public. Okay, section 73 says certain situations, okay, or it prescribes a procedure for raising deposits, and it also says that deposits cannot be raised from public. Okay, as per section number 73, deposits cannot be raised from public. That means deposits can be raised only from members as per section 73. Okay, that we can confirm here. Okay, section 73 speaks about raising deposits from members. Okay, now see section number 76, what it says. Section number 76, acceptance of deposits from public by certain companies. That means section 76 is speaking about raising deposits from public, from general public. Okay, from public. These two sections are important. Okay, section 73, which speaks about raising deposits from members. Members means from shareholders of the company. Okay, and section 76, which speaks about raising of deposits from general public. Hope this is clear. These are the two main sections. Okay, these two are the main sections. You can star mark them. Next, if you see section number 74, basically it is a transitory provision. Okay, transitory provision, which is irrelevant now. Okay, repayment of deposits etc. accepted before the commencement of this act. Okay, generally a period of 1 year was given. Okay, generally this provisions related to deposits have come into existence in 2014. Now if companies have raised deposits before 2014, then those deposits have to be repaid within 1 year from the date of commencement of these sections. That is from 2014, within 1 year they have to be repaid. Okay, now this section has become irrelevant because that period has already completed. Okay, this section is irrelevant. Next, section number 75, which deals with damages for fraud. Okay, just a 2 lines section. Okay, and section number 76A, which deals with punishment. Okay, punishment, even this is a 2 lines section. Thereby, once we complete section number 73 and section number 76, our discussion of this chapter gets completed. Okay, now this is the brief idea or brief structure of the sections. Okay, now first of all we will be discussing section number 73 and section number 76. Okay, after discussing these two sections we will move forward to remaining sections. Okay, now see, you remember that section number 73 deals with rising of deposits from members. Okay, that means from shareholders. From the existing members, the deposits can be raised by the company. That will be dealt by section number 73. And if company raises deposits from public, okay, from general public who are not members of the company, okay, in that case section number 76 will be dealing with that. Okay, now let me first of all explain in the form of chart. Okay, I will give a brief idea of section number 73 and 76 in the form of chart. After that we will be reading the section. Okay, first of all we will understand the entire concept that is there in the section. See, acceptance of deposits. Tell me, from whom deposits can be accepted? From two people deposits can be accepted. One is member, one is public. Same I will be writing. Acceptance of deposits from just a second. From members. Okay, in case of rising deposits from members, section number 73. Okay, and other one from public. For rising deposits from public, section number 76. These two sections we will be discussing together. Okay, now you know that deposits can be raised from members, from public, but which type of companies can rise from members, which type of companies can rise from public? Let us see that. Basically deposits can be raised from public only by eligible companies. Okay, see, raising deposits from public involves risk to the public. Thereby, Companies Act has not allowed all the companies to raise deposits from public. Okay, Companies Act has given certain criteria. Okay, certain eligible companies, only those eligible companies can raise deposits from public. Okay, we will see what are those eligible companies. And deposits from members. See, raising deposits from members is not riskier, because see, members means our shareholders only. Let's say there is a small private limited company. Okay, it has been incorporated by some family members only. Okay, wife, husband and his daughter. Okay, they have incorporated a private limited company. Now they want to raise deposits from members. That means from they themselves, they want to raise deposits from themselves only. Then that will not be any risky affair. Okay, in case they want to raise deposits from public, then that would be a somewhat risky affair. Okay, where public are involved. Thereby, deposits from members can be raised by both eligible and non-eligible companies. Okay, generally all the companies can raise deposits from members. Okay, we'll write it by both eligible and non-eligible companies. Okay, now the question arises, which are eligible companies? Let us discuss that. Eligible companies. Who are eligible companies? Let me write here. Eligible companies. Basically, there are three conditions that are given. Okay, if those three conditions are satisfied, then that company becomes eligible companies. Okay, you please don't write, you listen to the class. Later on I will give you the time to note down all these charts. Okay, now who are eligible companies? Basically there are three conditions that are given. What are those three conditions? First of all, eligible company means a public company with three conditions. Net worth of 100 crore or more and turnover of 500 crore or more and obtained special resolution in general meeting, that is from members, to raise deposits from public. See, first of all we have discussed that in order to raise deposits from public, only eligible companies can raise deposits from public. Now what are eligible companies? This is the definition of eligible companies. See, eligible company means, first of all it should be a public company. That means private companies are not eligible companies. That means private companies cannot raise deposits from public. Hope this is clear. First of all, to be eligible company, you must be a public company. Okay, therefore you can make it clear that deposits from public can be raised only by public companies. Hope this is clear. See, eligible company means public company with first criteria, net worth of 100 crores or more. Okay, and second criteria related to turnover of 500 crores or more. And third criteria is this company should have obtained a special resolution in the general meeting. Okay, from the shareholders of the company, it should have obtained a special resolution regarding permitting the company to raise deposits from public. Okay, simply the members of the company should have permitted the company through special resolution to raise deposits from public. Okay, if these three conditions are satisfied, then that company will be known as a eligible company. Hope this is clear. Again, what are the three conditions? First of all, company must be a public company, and first condition related to net worth of 100 crores or more. Second condition, turnover of 500 crores or more, and general meeting special resolution. Hope this is clear. And remember that all these three conditions must be satisfied, not any one of the condition. If you observe, I have written and. Hope this is clear. This type of company will be a eligible company. Okay, and eligible for what? Eligible for raising deposits from public. Okay, if it is not a eligible company, then it cannot raise deposits from public. It has to raise deposits only from the members. Hope this is clear. Okay, now that is the meaning of eligible company. Now deposits can be raised only by eligible company from the public, and from members. Both eligible and non-eligible companies can raise deposits. Now what is the okay, that one we'll discuss later. There are certain requirements that has to be satisfied. Okay, if you want to raise deposits from members or from public, you need to satisfy certain requirements. What are those requirements? Let us see. Firstly, basically these requirements will be discussed by section number 73 and section number 76. First of all, dealing with section number 73. Requirements. First requirement, or you can use A because the section uses clause A. That means you are a company, you wanted to raise deposits from members. Okay, you are not an eligible company. Okay, so you are not permitted to raise deposits from public, thereby you have decided to raise deposits from members. Okay, now what are the conditions that has to be satisfied? Okay, or what is the procedure, you can say, rather than conditions it would be better to call as procedures. Okay, what is the procedure that has to be followed in order to raise deposits from members? Let us see. First one, issue circular or advertisement in form DPT1. Okay, generally if you have studied SEBI, okay, there if company wants to raise money through IPO, then it will be issuing prospectus. Okay, in the prospectus it will be mentioned how much amount is being raised, and what is the purpose for which amount is raised, and what are the various business related financials. Okay, you can say as financials, and financials will be present in this prospectus. Okay, that is when company is raising money by issuing securities. Okay, if the company is issuing securities, then the company will give prospectus, but here deposits are not securities. Okay, we have discussed first only, deposits are not securities. Okay, if company raises deposits, it will issue deposit receive. Okay, basically there is some noise that has that is coming from outside, sorry. Now if company raises deposits, it will issue deposit receipt, okay, to that particular depositor. Thereby this deposit receipt is not a security. Thereby, since it is not a security, company will not issue prospectus. Okay, instead of prospectus, company will issue advertisement or circular. Okay, what will be present in this advertisement or circular? In this advertisement or circular, it will be present for which purpose the amount will be used by the company, and what will be the rate of interest for these deposits, okay, and how much amount that the company is raising, okay. All these details related to deposits will be present in this circular or the advertisement, okay, and this must be in the format of DPT1. Hope this is clear. Simply you can remember that if company wants to raise money through deposits, it has to first of all issue a circular or advertisement in form DPT1. That is the first step that has to be taken by the company. Next, file DPT1 with ROC 30 days before circulation to public or to members, you can say, or simply before circulation, okay. Now first of all, before circulating this circular or advertisement in form DPT1, you have to file this DPT1 with the registrar of companies, okay. What is the time limit? At least 30 days before you have to file it with the registrar, okay. Let's say you wanted to give advertisement related to raising of deposits on, let's say, some 15th of May 2021. In that case, you should file this DPT1 with the registrar at least by 15th of April 2021, okay. Ignore that one day this side or that side, okay. I have rounded it off. You should, in the 30 days, at least by 15th April 2021, you should have filed this DPT1 with the registrar. Hope this is clear. That is the second condition. Next condition, maintain deposit repayment reserve account. What is this deposit repayment reserve account? Generally you should have listened debenture redemption reserve, okay. Even this deposit repayment reserve is also similar to that of debenture redemption reserve, okay. Now company has to deposit certain amount in this deposit repayment reserve account. How much amount has to be deposited? Let's see. Now let's say this is the timeline, okay. Now today the date is 1st April 2021, okay. Today the date is 1st April 2021. Now by 30th of April 2021, it should deposit 20% of just a second of deposit amount, 20% of deposits maturing in following year. That means, see, generally the provision is company shall within 30 days from the beginning of each financial year deposit at least 20% of the deposit amount that are going to be matured in the following year. That means, let's say here, okay, in these periods before 1st April 2021, company could have raised some deposits, okay, raised deposits, okay. Let's say company has raised some 1000 crore deposits, okay. Now of these 1000 crore deposits, okay, here this is 1st April 2021 and let's say here. Let's say here. This is 1st April 2022. Okay, this is the next financial year. Now, of these 1000 crores, 100 crores, okay, 100 crores will be matured in this financial year. Okay, company has to repay 100 crores of deposit in this financial year. Okay, their maturity date is falling in this financial year. Now here 100 crores will have to be repaid in financial year 22-23 now. Thereby here, okay, in this period of this 100 crores, okay, which are going to be matured in the following year, okay, of this 100 crores, 20%, okay, that means 20 crores, at least 20 crores has to be kept aside as deposit repayment reserve. Hope this is clear. Okay, the provision is the company shall within 30 days from the completion of each financial year shall keep aside at least 20% of deposit amount that are going to be matured in the following financial year, okay, has to be credited to the deposit repayment reserve account. Okay, in our example, in the financial year 22-23, 100 crores are going to be matured. Thereby in the preceding financial year, okay, in this financial year, okay, at this, okay, after starting of the financial year, within 30 days we are depositing 20% of this 100 crores in the deposit repayment reserve account. Hope this is clear. Okay, like this the company has to maintain deposit repayment reserve account. This is the third condition. Here you can write 20% of deposits to be matured in following financial year, okay, has to be credited to DRR account within 30 days from the commencement of each financial year. That is the third condition. Next, fourth condition. Let me just yeah. Fourth condition. No subsisting default in repayment of debentures and 5 years should have elapsed from the date of making good last default. What is this? First of all, now company wants to raise deposits. Okay, if it wants to raise deposits, presently the company should not have any existing default in the repayment of deposits. Okay, already in the past company has raised deposit, okay, and those deposits have to be repaid by the company, and the company has defaulted in repaying in repaying that deposits. Okay, already company defaulted in repayment of deposits, and again now company wants to raise deposits. How will the Companies Act permit that company? Thereby Companies Act will not permit the company to raise deposits if it is already having a subsisting default in repayment of deposits or its interest. Okay, thereby the first condition is that there should be no subsisting default. Hope this is clear. And also this point, and 5 years should have been elapsed from the date on which, from the date of making good last default. That means, let's say in the past, now in 2021-2022 company wants to raise deposits. Okay, now in the past, let's say in 2012-13 company has defaulted in repayment of deposits. Okay, in the year 2012-13, and in that year company has defaulted, but in the next year, okay, in 2013-14 company has made this default good. That means actually the due date for repayment of deposits has fallen in 2012-13, but company was not able to repay the deposit in 2012-13, but in the next year in 2013-14 company has got the amount. Okay, thereby company has repaid these deposits in 2013-14, thereby company has made good the default. Okay, the default has been made good. Okay, now at least 5 years should have been elapsed from the date of from the date of making good the last default. Okay, now here when did the company made good the last default? In 2013-14 company has made good the default. Now 5 years should have elapsed from that date. That means 13-14 na 14-15, 15-16, 16-17, 17-18, 18-19. Okay, that means in 19-20 company can again raise deposits. Okay, 5 years. 5 years means till 19-20. Okay, in 19-20, from 19-20 onwards it can again raise the deposits. In this period, okay, in this period can't raise deposits. Hope this is clear. But in our present example, already 5 years has elapsed from the last date on which the default has been made good. Okay, thereby in 2021-22 the company can raise the deposits. There will not be any issue. Hope this is clear. Hope you understood this example. That was our fourth condition, and we are left with the final condition. Just a second. Let me drag this here. Now the final condition. If secured deposits create proper charge. See, basically company is raising deposits from the public or the members. Now what is the guarantee that company will repay the deposits? Okay, either the public or the members, they will not rely on the company. Okay, thereby they want some security to be given. Okay, in order to raise deposits, the company has to give some security. Okay, thereby if the company gives any security, okay, if the deposits are secured deposits, then proper charge has been created. Generally, see, if company raises deposits from members, then those deposits can be either secured or unsecured. Okay, if the company is raising deposits from members, it can raise unsecured deposits also. Okay, there is no mandatory requirement in the act that company has to raise secured deposits only from the members, because it is raising deposits from the members only. Okay, they are inside people only. Thereby, even though company doesn't offer any security, there will be no issue. Okay, thereby if company is raising deposits from members, those deposits can be either secured or unsecured. But if company is raising deposits from public, okay, if it is raising deposits from public, means here public are involved. If anything wrong happens, then the interest of the public will be affected. Thereby the deposits which have been raised from the public must be secured. Okay, now how the security will be created? Generally by giving some charge, okay, by creating some charge on either movable property or immovable property of the asset, the security will be created. Okay, here the fifth condition says that in case, okay, because we are discussing the conditions for raising deposits from members. Okay, thereby if you are raising deposits from members, means you can raise it either secured deposits or unsecured deposits. Thereby, if here I use the term if, okay, if they are secured deposits, then create proper charge on the assets of the company. Hope this is clear. Now there is another point. Generally in the act, okay, in the Bare Act, here we have discussed 5 points now: A, B, C, D, E. Okay, basically in the Bare Act, earlier we were having 6 points. Okay, A, B, C, D, E, F we were having. Actually, okay, here this point is not D, this is E and this is F. In the middle we were having point D. Okay, here we were having point D, but now this D point has been omitted. Okay, it has been deleted in the Bare Act itself. Basically what this D point was, okay, this condition was related to deposit insurance. Okay, generally what happened was, earlier government, the law, in the law it was specified that the company which is raising deposits, it must also take a insurance on those deposits. Okay, that provision has been kept in the act. But if you see in the market, there were no insurance companies that were offering insurance on these deposits. Okay, actually in the 2014 this act has come now, this provisions has come into effect now. From that time onwards, in the government has been extending this time. Okay, it has been saying that by next 1 year you should get the deposit insurance. Okay, but companies are not able to find any insurance companies which are offering insurance on these deposits. Okay, thereby government kept on increasing this time. Okay, and finally after some 6 to 7 years, even government came to know that there are no insurance companies that are willing to offer this deposit insurance. Okay, thereby if there are no insurance companies which are offering deposit insurance, means how can the companies that are raising deposits can get the deposit insurance? Thereby this provision itself has been removed now. Okay, now there is no concept of deposit insurance. Okay, hope this is clear. Thereby point D has been omitted and we are left with only 5 points. Hope this is clear. Now, and also there is another condition here. If you want to raise deposits from members, you should get a general meeting ordinary resolution. Okay, first of all you should get approval of members through general meeting ordinary resolution. Hope this is clear. In case you wanted to raise deposits from public, then you need general meeting special resolution. Why special resolutions are? Because if you see the definition of eligible companies, okay, only eligible companies can raise deposits from public, and in the eligible companies, one of the condition is that it needs to obtain special resolution in the general meeting. Okay, only if it obtains general meeting special resolution, it will be a eligible company to raise deposits from public. Thereby, to raise deposits from public, general meeting special resolution is required, and to raise deposits from members, general meeting ordinary resolution is sufficient. Hope this is clear. Now moving to that is section number 73. Okay, basically this is the content that will be discussed in section number 73. Okay, we will also read the section, okay, after discussing this section number 76. Hope you understood all these. Okay, once I will again repeat them. Okay, from first onwards I will revise. See, first of all, company wants to accept deposits. Deposits can be raised either from members or from public. Now, the rising of deposits from members will be governed by section number 73, and rising of deposits from public will be governed by section number 76. Now, who can raise deposits from public? Only eligible companies can raise deposits from public. Okay, now what are eligible companies? There are basically 3 conditions. First of all, an eligible company must be a public company. Okay, private company cannot be a eligible company. That means private company cannot raise deposits from public. Okay, now eligible company means a public company. First condition, related to net worth of 100 crore or more. Okay, and second condition, turnover of 500 crores or more, and third condition, general meeting special resolution. Okay, if these 3 conditions are satisfied and that company is a public company, then that will become eligible company, and only eligible companies can raise deposits from public. Okay, that is section number 76. Now section number 73. Now, in order to raise deposits from members, you need general meeting ordinary resolution. In order to raise deposits from public, you need general meeting special resolution. Now, in order to raise deposits from members, there are certain 5 conditions. Okay, or you can say a procedure that has to be followed. What is that procedure? First one, company needs to issue circular or advertisement. Okay, in form DPT1. We should not call this as prospectus, because prospectus will be issued for raising money by issue of securities. You cannot call these deposits as securities. Thereby, you can only issue circular or advertisement. You cannot issue prospectus for raising deposits. And second one, you need to file this form DPT1, okay, that is circular or advertisement, with ROC at least 30 days prior to circulating that to the members or the public. Okay, next, third condition, deposit repayment reserve must be created, and you must credit at least 20% of deposit amount that is going to be matured in the following year. Okay, to this deposit repayment reserve you have to credit. And also another condition is that there must not be any subsisting default, okay, in repayment of deposits, and at least 5 years should have been elapsed from the date of making good the last default. Okay, even that condition has to be satisfied. And the fifth condition, if the deposits are secured deposits, there must be proper charge created over that deposits. Hope this is clear. And in case of rising deposits from members, those deposits can be either secured or unsecured, and in case of rising deposits from public, those must be secured. Hope this is clear. Now we'll see conditions for rising deposits from public. Basically, all the conditions that we have discussed here, okay, from point number A to E, okay, all these conditions here to here, point number A to E, A requirements, A to E, okay, you should not consider this F point, okay, because the F point says if secured. Since the deposits were members under section 73, we used the term if secured, but for rising deposits from public, they must be secured. Thereby you should not use the F point there, okay. Only A to E, only 4 points, plus shall be secured, and also obtain credit rating, okay, yearly. You should obtain this credit rating yearly. What is this credit rating? Generally, if you want to watch movies, you will go to cinema theater by seeing the rating of that movie, okay. You will be first of all seeing what is the IMDb rating for that movie. If the rating is above 8, okay, or 9, only then you will go to theater and watch that. In the same way, if public will take the decision of whether to invest in these deposits or not based on the credit rating that has been obtained by the company, okay. Generally there are various organizations that will be giving this rating, okay, like CRISIL, CARE, Fitch, and S&P. Like this we are having various credit rating agencies, okay. From them credit rating has to be obtained, and for each year the credit rating has to be obtained, okay. Every year the credit rating has to be obtained. Hope this is clear, okay. Just a second, I'll just close this and open again. That's it. We are done with section 73 and 76. You take notes of these sections. I'll just come, okay. From here you make a note. This introduction, if you want, you can make a note, okay. You can pause the video and you can make a note, okay. You note down, I'll just come. Hope you are done with this. Otherwise, you can pause and you can make a note. You can write this. These are securities. These are depository receipts. And these deposits will be governed by Companies Act. Next, you can make a note of this. You can pause and you can, or first of all, you keep that heading. You write these two. Okay, you divide it into two: members, public. Okay. After that, first of all, write down this members portion. Okay. Till here you write down. Okay. If you are not done, you can pause and you can write. I'm scrolling it. Next, make a note of this. Point number F. You can pause and you can make a note. Okay. Next, moving to here. Only E to F in the public portion, rising from public. Point A to E. Okay. Plus shall be secured and obtain credit rating. Okay. Hope you are done. Now, next, what are eligible companies? You can write down this. Eligible companies. 3 conditions. You can pause and you can make a note. Okay. Hope you are done. I'm scrolling. Next. This one. You can write this example. Okay. Here you can keep heading as deposit or DRR account. DRR account. Okay. And you can write down this timeline. You can pause and you can make a note. Okay. Next, this one, this point. This one is example related to making good last default. Okay. 5 years, at least 5 years should have been elapsed from the date of making good the last default. Okay. Hope you are done with this. Next, is anything left yet? I hope that's it. Yes. Now we'll just read from our book what is there. Let me see what is the time. Okay. Now, first of all, he has given the definition of deposits. Deposit includes any receipt of money by way of deposit or loan or in any other form by a company, but it does not include such categories of amount as may be prescribed in consultation with RBI, section 231 of the Companies Act 2013. See, deposit means any amount that has been raised either in the name of deposit or in the name of loan, but it does not include certain amounts which are specified in consultation with RBI. What are those amounts? Let's say, for example, there is a banking company. Okay. From that banking company has a, okay, our company A Limited has raised some loan Okay, now you cannot call this loan as deposit, okay, because this amount of loan is raised by raised from banking company. Okay, those types of loans will be specified, okay, in this particular section 2 subsection 31. Okay, apart from those types of amounts raised by the company, okay, remaining amounts whether raised in the name of deposits or in the name of loans will be called as deposits. Basically there is a big definition, okay, that has been given. Okay, generally it will take around 2 to 3 hours to discuss that definition only. Okay, but hopefully our institute has not given that definition in the syllabus. Okay, we don't have that definition in the syllabus. Okay, thereby you need not learn it. Okay, now provisions as to acceptance of deposits by companies have been considerably modified and made more stringent from section 73 to 76 under chapter 5 of the Companies Act 2013. Okay, basically these provisions, section number 73 to 76, will be present under chapter 5 under the name acceptance of deposits by companies. Deposits used to be very good source for short term capital. Okay, generally this deposits would be a very great source for the companies for raising the short term capital. Okay, for short term capital purposes these deposits would be very good. Okay, because the tenure of these deposits would be some 6 months to 3 years. Okay, generally short term capital means less than 1 year. 1 year to 5 years means it would be medium term capital, and above 5 years means that would be long term capital. Okay, these deposits would be falling in both short term and medium term capital sources. Okay, and it used to be regular course of income for the retired persons. Okay, if you deposit amount with the banking companies, the rate of interest that will be offered by banking companies is very less. Okay, they might offer some 6%. Okay, but if you deposit this amount with the companies, okay, they will offer around 9 to 10% of interest. Okay, thereby it used to be a good source of income for the public. Okay, but however there is risk involved in this. Okay, keeping this risk in view, okay, our Companies Act has allowed only certain companies to raise deposits from public. Okay, like big companies. Okay, all those conditions, share net worth of 100 crores, turnover of 500 crores. Okay, basically a very large companies will be falling under those criteria. Okay, only those types of companies can raise deposits from public. Okay, however from members other companies can raise. There is no restriction for raising deposits from the members. Okay, however with the series of defaults by companies, investors lost faith on the companies. Okay, earlier the rules or the laws related to this deposits from public were not that much stringent. Okay, due to that many companies used to raise deposits from the public and they were not repaying the deposits. Okay, this was causing a huge loss to the public. Okay, thereby considering this, now the laws related to acceptance of these deposits have been made more stringent. Okay, presently few companies are trusted for keeping deposits. Companies now have various alternate sources. Okay, now moving to our first section number 73. Section number 73, what I have told you, for raising deposits from members. Okay, let us see what section number 73 says. The name of section number 73 is prohibition on acceptance of deposits from public. Okay, that means it can rise from members. Okay, section 73 speaks about rising deposits from members. Now, no company can invite, accept or renew deposits under this act from the public except in a manner provided under this chapter. Okay, the basic rule is that no company can raise deposits from public. Okay, it has given basic rule. Okay, a blanket prohibition saying that no company can raise deposits from public except as provided under this chapter. Okay, except companies that are specified here. Okay, apart from those companies, other companies cannot raise deposits from public. What are those specified companies? Eligible companies that we have discussed. Okay, that we will be covering. We'll get the definition of eligible company also. See, provided that nothing in this subsection shall apply to a banking company and non-banking financial company and to such other company as the central government may, after consultation with Reserve Bank of India, specify in this behalf. See, if you see, the main business of banking company and NBFCs is to raise deposits from public and give loans to public. Okay, this is the main business of the banking industry. Okay, if you prohibit these banks from raising deposits from the public, or if you keep more stringent rules, okay, you are saying to the banking company that generally if these deposit sections, okay, from section number 73 to 76A, okay, if these sections were applied on the banking company, then for raising deposits from the public, it needs to obtain general meeting ordinary resolution. Okay, for taking money from the public, if every time the banking company has to get a general meeting ordinary resolution, means it would not be feasible to the bank. Okay, thereby for banking companies and NBFCs, these provisions are not applicable. Okay, the provisions that we are going to discuss in this deposits chapter will not be applicable for banking companies and NBFCs and such other companies as may be specified by Reserve Bank of India. Okay, after consultation with Reserve Bank of India, other companies as may be specified by the Companies Act. Okay, for all those companies, these deposits provisions will not be applicable. Hope this is clear. Next, a company may, with the mandate of resolution in the general meeting. Okay, here resolution means general meeting ordinary resolution. If it not specifically specified as a special resolution, you can assume it as ordinary resolution. Okay, if you see here, it says company may with mandate of resolution. Okay, here it is not written as special resolution, so you can assume it as ordinary resolution. Hope this is clear. Now, I hope you know what is the difference between ordinary resolution and special resolution. Okay, simply remember that ordinary resolution means majority. Okay, 51%. Special resolution means 75%, you can say. Okay, now, and subject to such rules as may be prescribed, accept deposits from its members. See, if you observe, it says members, not public. Okay, subject to such rules as may be prescribed, accept deposits from members on such terms and conditions, including the provision of security, if any, for the repayment of such deposits with interest as may be agreed upon between the company and its members, subject to fulfillment of following conditions, namely. Okay, what are the conditions that has to be satisfied in order to raise deposits from members? Okay, those 5 conditions which we have discussed are listed here. See, let us see. First one, issuance of circular to its members, including therein a statement showing the financial position of the company, the credit rating obtained, total number of depositors, and the amount due towards deposits in respect of any previous deposits accepted by the company, and such other particulars in such form and in such manner as may be prescribed. First of all, it must give a circular or advertisement, you can say. Now, what has to be included in this advertisement? See what he says, financial position. What is the financial position of the company? That has to be written. And if the company has raised any deposits in the past, okay, then what are the outstanding deposits that the company is already having, and how many members from which the company has raised deposits. And now the company is going to raise deposits. Now what is the credit rating that the company has obtained? Okay, all these details must be present in this circular. And what should be the format of the circular? He says in such form and such manner as may be prescribed. Okay, basically it is in DPT1. Okay, the format is DPT1. That is the first condition. Okay, next, filing a copy of circular along with such statement with the registrar within 30 days before the date of issue of circular. Okay, the second condition is file this form DPT1 with registrar at least 30 days before issuing it to the members. Okay, that is second condition. Third condition is related to DRR, deposit repayment reserve account. See, depositing on or before 30th April each year such a sum which shall not be less than 20% of the amount of its deposits maturing during a financial year and kept in a scheduled bank in a separate bank account to be called as deposit repayment reserve account. Okay, this amount of deposit repayment reserve must be kept in a separate scheduled bank account. Okay, you have to open a separate bank account in order to maintain this deposit repayment reserve. Hope this is clear. Next, and what is the percentage? 20% of the amount that is going to be matured in the following year, and by when it has to be deposited? By within 30 days from the start of the financial year. Okay, you can find it by 30th April, and each year, every year till the entire deposits are repaid. Okay, till that time you have to keep on depositing at least 20%. If you want, you can also deposit more than 20%. Okay, but at least 20% must be deposited. Okay, you cannot deposit less than 20%. Hope this is clear. Next, certifying that the company has not committed any default in the repayment of deposits accepted either before or after the commencement of the act. Okay, that means there should not be any subsisting default. The company should not have defaulted, or payment of interest on such deposits. Okay, and where the default has occurred, in case default has occurred in the past, then the company made good the default and 5 years has elapsed since the date on which the default has been made good. Hope this is clear. Okay, 5 years has been elapsed since then. Hope this is clear. Next, that was our fourth condition. Moving to the fifth condition, providing security if any. Okay, you can find the term if any. In case the deposits are secured deposits, then the charge has to be created. Okay, that is the reason why they used the term if any. Okay, because these deposits are being raised from members, thereby it is not mandatory that these deposits must be secured deposits. Okay, even unsecured deposits can be issued to members. Hope this is clear. Thereby providing securities if any for the due repayment of the amount of deposit or the interest thereon, including the creation of such a charge on property or assets of the company. Okay, now you are saying that in case the deposits are secured deposits, you provide the security. For how much of amount the security has to be provided? Let's say total deposits that the company raised are some 100 crores. Okay, and tenure of deposits is 3 years, and rate of interest is 10%. Now, for how much amount the deposit, the security has to be provided for? Okay, basically security has to be provided for both principal and interest. In this case, principal is 100 crores plus interest is 3 years at rate of 10%. That becomes 30 crore. Thereby, security has to be provided for 130 crores. Hope this is clear. Okay, charge on the assets of the company has to be created for 130 crores. Okay, and also company will appoint some trustees for these deposits. Okay, there is that concept of trustee also that we will be discussing. Next, provided that in case where a company does not secure the deposits or secure such deposits partially, then the deposits shall be termed as unsecured deposits. See, if the company has secured the deposits, then those deposits will be called as secured deposits. Let's say company has not secured the deposits. Okay, it has not created any charge on the deposits. In that case, they will be known as unsecured deposits. And another situation, let's say company raised deposits of 100 crores. Now of these 100 crores, for 50 crores the security has been created. Okay, charge has been created, and for balance 50 crores no charge has been created. Okay, this will be a type of partially secured deposits. Now the act says that even partially secured deposits will be treated as unsecured deposits only. Hope this is clear. Next, and shall so be quoted in every circular, form, advertisement, or in any document related to invitation or the acceptance of deposits. Okay, in case you are issuing unsecured deposits, then the fact that these deposits are unsecured must be mentioned in all the advertisements and the circulars that you issue for raising the deposits. Okay, because public should know the fact that these deposits are unsecured deposits. Okay, next, note, in case of private company, clause A to E of subsection 2 of 73 shall not apply to private companies which accept from its members monies not exceeding one. Okay, this point we'll discuss later. Now you will not understand this point, we'll discuss it later. Okay, I am keeping this point as pending. Okay, pending, we'll discuss it later. Okay, after discussing the tenure point we will discuss it. Next, every deposit accepted by company shall be repaid with interest in accordance with the terms and conditions. Okay, all the deposits accepted by the company must be repaid within the due date as per the terms and conditions. Where a company fails to repay the deposit or part thereof or any interest thereon under subsection 3, the depositor concerned may apply to the tribunal for an order directing the company to pay the sum due or for any loss or damage incurred by him as a result of such non-payment, and for such other orders as the tribunal may deem fit. Okay, generally as per subsection 3, company has to repay the deposits on the maturity date. Okay, within the due date it has to repay the deposits. In case company fails to repay the deposit, then the depositor, okay, the person from whom deposit has been raised, that person can approach a tribunal. Okay, NCLT, National Company Law Tribunal. Okay, he can approach National Company Law Tribunal and complain against the company. Okay, asking the National Company Law Tribunal to direct the company to repay the deposits. Hope this is clear. That option is available to the depositor. Hope this is clear. He can approach NCLT against the company. Next, the deposit repayment reserve account referred to in clause C of subsection 2 shall not be used by company for any purpose other than repayment of deposits. The detailed procedure is mentioned under company's acceptance of deposit rules 2014. Some of the rules are summarized and placed below for the understanding. Okay, now we have seen that the company should maintain deposit repayment reserve. Now the amount that has been kept in this reserve must be used only for the purpose of repayment of deposits. Okay, because the name itself suggests that is kept aside for repaying the deposits. You should not utilize this amount for any other purposes. Okay, yes, that was section number 73 relating to raising deposits from members. Okay, the first part is completed. Okay, in our chart the first part got completed. Moving to second part. Okay, that is raising deposits from public. Section number 76, accepting of deposits from public by certain companies. What are these certain companies? Eligible companies. See, the definition of this eligible companies is relevant only for this chapter. Okay, only for the chapter of this deposits. Okay, only for this chapter, acceptance of deposits by companies. Okay, only for this chapter the definition of eligible companies is relevant. Okay, you should not apply this definition in other chapters. Okay, what is the definition of eligible companies? See, notwithstanding anything contained in section number 73, a public company, okay, eligible company must be a public company having such net worth of 100 crores, okay, or turnover of 500 crores as may be prescribed, may accept deposits from persons other than its members. Okay, here I think, sorry, there is a small correction that has to be made in the definition of this eligible company. Just a second. Here you replace this with or. Okay, net worth of 100 crore or more, or turnover of 500 crore or more, and okay, here it will be and only. Okay, first it will be or, next it will be and here in this point I have discussed as general meeting special resolution. Now you strike it off and make it as general meeting ordinary resolution or special resolution. Why, sir? Why ordinary resolution or special resolution? I'll tell you. There is a linking with section number 180. I forgot that linking, and I told you it as general special resolution. Sorry, I'll explain you that linking. Okay, basically it is related to section number 180. I'll explain it. See, what all the points that we have discussed till now, all are same, just that you make this correction of replacing and with or. That means if any one of these condition has to be satisfied, okay, either net worth condition or turnover condition, okay, any one of these condition, and here it should be and, okay, and approval of general meeting through special resolution or ordinary resolution. Okay, when special resolution has to be obtained, when ordinary resolution has to be obtained, let us see. Basically this is linked to section number 180. What section number 180 says? Basically section number 180 is related to limitation on the powers of board of directors. Okay, as per section number 180 subsection 1 clause C, okay, as per that, if company wants to raise borrowings, okay, company wants to raise borrowings, okay, and here there will be two situations. First one is existing borrowings plus proposed borrowings. I'll note down the chart, later on I'll explain you. Existing borrowings plus proposed borrowings, okay, these two are less than or equal to paid up share capital plus free reserves plus security premium of the company. Okay, if this is the case, then the company has to obtain general meeting ordinary resolution for the proposed borrowing. Okay, existing borrowing, however, it is there in the company. Okay, now company wants to raise some more borrowings. Okay, after raising these borrowings, the existing borrowings plus proposed borrowings, okay, these both together are less than or equal to paid up share capital of the company, free reserves of the company, and securities premium of the company. Okay, if you add up that all three, and if you add up this existing borrowing plus proposed borrowing, this is less than this three. Okay, in that case, general meeting ordinary resolution is required. Okay, we will understand this with the help of examples also. Okay, let me draw up the chart. Basically, this linking is very important. I forgot to tell you that. Next, if existing borrowing plus proposed borrowing, these two are greater than paid up share capital plus free reserves plus securities premium. Okay, in this case, you need general meeting special resolution. Okay, for proposed borrowing. Okay, this is where, as per section 180, okay, if you want to raise borrowings, okay, here you are raising deposits, okay, from public, that is borrowing only. Okay, now this proposed borrowing along with existing borrowing is less than or equal to paid up share capital, free reserves plus security premium, means you need general meeting ordinary resolution. If it exceeds that, then you need general meeting special resolution. Now let us understand. See, let's say paid up share capital of the company is some 400 crore. Okay, and free reserves of the company are some 300 crore, and securities premium of the company are some another 300. Okay, another 300 crore. Okay, thereby this total is 1000 crores. Okay, now company is already having existing borrowing. Okay, this is case 1. In case 1, existing borrowing is, let's say, some 800 crores. Okay, and proposed borrowings. Okay, now company wants to raise deposits. Okay, this is proposed borrowings. Proposed borrowings, that are deposits. Now the proposed borrowings are, let's say, 100 crores. Okay, now this total existing borrowings 800 crores plus proposed borrowings in the form of deposits from the public is 900 crores. Okay, this 900 crores is less than the 1000 crores. Thereby company requires general meeting ordinary resolution. Okay, next case, second case, existing borrowings 800 crores. Let me use another pen. 800 crores. Next, proposed borrowings. Now the company wants to raise 300 crores. Okay, in that case total becomes 800 plus 300, 1100 crores. Okay, now it is exceeding this 1000 crores, thereby general meeting special resolution is required. Okay, this is how section number 76 is linked to section number 180. Okay, regarding these two. Okay, general meeting ordinary resolution or general meeting special resolution. Hope this is clear. Thereby you can also change it here. General meeting special resolution or ordinary resolution as per the requirement of section number 180. Okay, all that point we have discussed now. In case of raising deposits from members, it will not be counted as borrowings. Okay, because you are raising it from members only, thereby general meeting ordinary resolution is sufficient, because section number 73 specifically mentions that resolution is required. Okay, thereby you can take it as ordinary resolution only. Okay, but section number 76 does not mention any resolution. Okay, the term resolution is not mentioned. And if you see in the definition of eligible person, there he will mention, if you read the Bare Act, there he mentions reference to section number 180. Okay, that is the reason why if you are raising deposits from public, you will be requiring general meeting either special resolution or ordinary resolution as per the requirement of section 180. But raising deposits from members, general meeting ordinary resolution is sufficient. Hope this is clear. Now what you will do is, first of all, you go to this chart, acceptance of deposit chart. Okay, in this chart here, earlier you would have written general meeting special resolution, there you keep this mark and write ordinary resolution. Okay, first of all make that change. After making that change, you go to definition of eligible companies. Okay, in that eligible companies you will find net worth of 100 crores or more, and you will find, you erase that and write or. Okay, and next you will find and, that you keep as it is. After that, in the third condition, you would have written general meeting special resolution. Okay, there you keep oblique and write ordinary resolution also. Okay, now below that point write this section number 180 subsection 1 clause C. Okay, sorry, I missed it to explain. Okay, you can make a note of this. Hope you are done. Otherwise you can pause and you can make a note. Okay, I'm scrolling. You can also write down this example. Okay, yes, now we'll read that section. Section number 76, right? See, notwithstanding anything contained in section number 73, public company having net worth of 100 crore or turnover of 500 crore as may be prescribed may accept deposits from persons other than its members. Okay, that means it can accept deposits from public. Okay, here you can also write the condition of general meeting, ordinary resolution or special resolution. Okay, even that condition you can mention here. Okay, I think it might be printing mistake that is missed. Okay, while giving the book I will change it and I will give you. Here you can write down the third condition also. Okay, general meeting, ordinary resolution or special resolution. Okay, next. Provided that such a company shall be required to obtain rating including its net worth, liquidity and ability to pay its deposits on due date from a recognized credit rating agency for informing the public the rating given to the company at the time of invitation of deposits from the public, which ensures adequate safety, and rating shall be obtained for every year during the tenure of deposits. Okay, if you are raising deposits from public, obtaining rating is mandatory. Okay, and it should be obtained for each year. Okay, till the deposits have been repaid. Hope this is clear. Next, provided further that every company accepting secured deposits from the public shall within 30 days of such acceptance create a charge on its assets of an amount not less than amount of deposit accepted in favor of deposit holders in accordance with such rules as may be prescribed. Okay, in order to raise deposits from the public, those deposits must be secured deposits. Okay, and charge on the assets of the company must be created within 30 days from the date of raising deposits from the public. Okay, next. The provisions of this chapter shall mutatis mutandis apply to the acceptance of deposits from the public under this section. Okay, not only section number 76 is applicable to raising deposits from public, even section number 73 is also applicable. Okay, the conditions that are prescribed in section number 73. Okay, in section number 73, conditions prescribed were those that are required for raising deposits from members. Okay, that conditions are prescribed. Now here if you see, the provisions of this chapter shall mutatis mutandis apply to acceptance of deposits from the public under this section. That means conditions prescribed in section number 73 will also be applicable to deposits raised from public. Okay, that is the reason why, if you observe in our chart, we have written same point number A to E. Let me show you here. Okay, this one, point number A to E or mutatis mutandis applicable to raising deposits from public also. Okay, not only this requirements, even all other requirements that we will be discussing in the chapter will be applicable for raising deposits from public also. Hope this is clear. Next, acceptance of deposits without compliance of Act, rules and notification would attract penalty and prosecution as per the Act. Okay, if you don't comply with these provisions while raising deposits, then there are certain penalties that are prescribed. Okay, even that penalty section also will be discussing. Next, note, eligible company for acceptance of public deposit. Basically, I think you have to make a correction in this definition. See, eligible company for acceptance of public deposit. Rule 2A of companies acceptance deposit rules define eligible company, which means a public company with a net worth of 100 crores. Here you write or turnover of minimum 500 crore and have consent of shareholders through special resolution or ordinary resolution to accept public deposits. Okay, while I am giving the material to you, I will make these changes and I will give you. Okay, don't worry. That is section number 73 and section number 76. Now there are certain terms and conditions, okay, that are prescribed. Let me see whether we can discuss them now or in the next class. Okay, we will discuss the remaining concepts in the next class. Okay, take care, bye bye, we will meet in the next class.